It's now exactly 8 o'clock. Today, the 6th of April, 2021. Top of the morning to you and welcome to the program. This is The Edge, 105 FM. And my name is Richard B. We go until 10 o'clock this morning. Welcome now to the Legal Landscape. It's a feature that we have every Tuesday morning at 8 o'clock here on this station. I've been telling you all morning that today's topic is going to be restrictive covenants, what they are and how they might affect you. This is a feature that is done in tandem with our friends at DunnCox Attorneys at Law. And we're joined this morning by Christina Brown, who is an attorney at DunnCox. Good morning, Christina. How are you today?
Good morning to you, Richie. I'm fine, thank you.
Wonderful. How was the long Easter weekend for you?
It was very quiet. It was very restful.
Absolutely. Wonderful to hear that. All right. Now, for some Jamaican landowners, Christina, the term restrictive covenant has very little significance, although it is a common feature of registered land titles. This very elusive concept of land law gained national attention, we understand, in 2020, mainly due to two landmark Supreme Court cases concerning residential developments. As more landowners become aware of their rights, the consequences, we understand, of breaching restrictive covenants become even more evident. So I want to ask you my first question this morning. What is a restrictive covenant?
Okay, so a restrictive covenant is basically an agreement that restricts the use of one landowner's property for the benefit of another or several others. And restrictive covenants can be found on most registered land titles, and they have certain unique characteristics. One of them is that they're negative in nature. So they basically require a landowner not to do something on their land. They're also made for the benefit of other lands, as I would have mentioned in the definition, and they're said to run with the land. So what that means is that they're enforceable both by and against future landowners and not just the original parties to the agreement.
Pretty much all land titles have these covenants, would you say?
Most of them.
Most of them.
Right, most of them.
And how are restrictive covenants imposed on a land title?
Okay, so restrictive covenants may be imposed on a title by a land developer, or they may be imposed as conditions of approval when an application for subdivision is made to the local authority. And their purpose is really to preserve the physical, social, and economic integrity of a certain neighborhood. So you'll find that they'll control things such as lot size, the architectural design of a building, distances between buildings and boundaries, and they may also regulate the kind of activities that can be conducted on land. Right.
Like if you want to move from a single-family dwelling to
multi-family dwelling,
and so on and so forth. Yes.
Yeah.
When does the need, though, for modification or discharge of a restrictive covenant arise? Yeah.
Okay, so it can arise in different circumstances. For instance, when there's some kind of development activity taking place on land or about to take place. So if you're a developer and let's say you acquire a parcel of land to lay out lots for a housing project, but there's a covenant on your title against subdivision, that covenant will have to be modified or even discharged to allow for the proposed subdivision. Another instance is when there's an actual breach of a restrictive covenant. And in some cases, Richie, a breach isn't discovered until a landowner is selling a property. And, a surveyor's report discloses that there's a breach. And of course, when that happens, a decision will have to be made as to how the breach is going to be addressed.
Yes.
So that is, something that could trigger either an application for a modification or a discharge of the covenant in question.
It doesn't make sense to breach at all because we know what has happened on several developments in Kingston that have been in the news for some time, eh?
Right, that is correct.
What is the procedure, though, for modifying or discharging a restrictive covenant?
Okay, so Section 3.1 of the Restrictive Covenants Discharge and Modification Act allows a landowner or another interested party to apply to the Supreme Court for an order, either modifying or discharging a covenant on certain grounds. Now, the application is made by way of a fixed date claim form and an affidavit in support, and it must be served on the local authorities. So at the first hearing of the application, if there are no objections from the local authorities, then the judge will issue certain directions, which will include serving notices on adjoining landowners, advertisements in the newspaper, filing certain affidavits, etc. And after these directions are complied with, a date is then set for the final hearing of the application. Now, at the final hearing, again, if there are no objections, either from the local authorities or, let's say, from adjoining landowners, then the court will grant the final order modifying or discharging the covenant. And it is that final order that will then be endorsed on the certificate of title for the landowner. So that's a procedure in a nutshell.
Is it something that generally takes a long time to get done?
Yes, it can take up to a year.
Up to a year.
It can take up to a year, yes.
And you have to get the consent, it seems, of your neighbors.
You have to serve them with notice of the application.
Yes. So I think this points me to my next question. If I'm a landowner and I receive notice that my neighbor is applying to modify a covenant, what are my options?
Okay, so once you're entitled to the benefit of the covenant in question, you can actually object to the application to preserve the benefits which you enjoy. So let's say, for example, there's a covenant on your neighbor's title that restricts the type of buildings on the land to single-family dwellings only, and he or she wants to modify the covenant to allow for an apartment complex. You know, you have a right to object to the modification. Whether or not that right is exercised, though, is entirely up to you. What I want my listeners to note, though, is that, you know, if you intend to object to an application, you have to file that objection within 14 days of the date that the notice was given. So it's very important that, you know, you consult with your attorney immediately after you receive the notice, and most likely you receive it by a registered mail. You know, so consult your attorney immediately to ensure that you're not out of time. Okay,
14 days is the time allotted. Okay. Now, what are some of the consequences that a landowner may face if a restrictive covenant has been breached?
Okay, so the consequences will vary depending on the nature and the extent of the breach. So if you're dealing with a minor breach, say for instance, a gate opening outwards when it should open inwards, that is something that could easily be remedied without any consequences. But where you have multiple breaches, especially when the breaches are very serious, you could actually have challenges in selling your property, you know, especially if the purchaser requires a mortgage loan to finance the transaction. You could also be unable to use your land title as security for a loan. And worst case scenario, you could be ordered by a court to demolish or, you know, make certain expensive changes to a building that is, you know, done in breach of a restrictive covenant. And we have the examples of the developers in the Upper Montrose Road case, which we heard about last year. I believe it was in January that the decision was handed down. Yes. So there could be other consequences, but those, I would say, are some of the major ones.
I think there's also a case of a building that had to be demolished on, is it South Avenue? I think it was. Years ago, that was anyway. My next question, though, Christina, is how can a landowner avoid the consequences that flow from a breach of a restrictive covenant?
Okay, so it's very important that, you know, you sufficiently familiarize yourself with the covenants on your title. They are not there for decoration. They serve a purpose. So if you're a developer, you need to ensure that you obtain an order for modification or discharge of a restrictive covenant before you start constructing. And if you're a homeowner and, you know, you want to make certain alterations or extensions to a building, you need to pay close attention to the restrictive covenants on your title, especially the ones that relate to minimum distance requirements. And you also need to ensure that you obtain the relevant approvals from the local authority.
Minimum distance requirements. For instance, you cannot build closer than 10 feet to the next neighbor's boundary and so on and so forth.
Right. Or 30 feet from a road boundary.
Yes. All right. I found it quite interesting. I really appreciate all the information that you shared with us this morning, and I'm sure that my listeners did as well. Before you go, though, Christina Brown, I'd like to get your did you know tidbit, if you have one. Do you?
Okay, I do, and I'm just going to keep it simple for today. So it is, if you don't comply, you might have to modify.
If you don't comply,
you might have to modify.
You might have to modify. All right. Appreciate that. Makes a lot of sense. Thank you so much for the information you shared, and I wish you a wonderful day.
Thank you. You too.
All right. And take this with you. Christina said the restrictive covenants are not there for decoration. They're very, very important clauses on your title. Don't overlook them. If you do, it could be to your detriment. All right, restrictive covenants, what they are and how they might affect you. That was the focus this morning. And we had with us Christina Brown, attorney at law at DunnCox, dissecting that subject so very well. We appreciate it. Join us again next Tuesday morning at the same time, 8 o'clock in the morning, when we will have The Legal Landscape, courtesy of The Edge 105 FM and our partners, DunnCox, attorneys at law.